From the opinion pages of the Wall Street Journal, this is Potomac Watch.
Nikki Haley draws a contrast in the Republican primary field on abortion as the Supreme Court stays a lower judge's ruling on Mifepristone. Welcome, I'm Kyle Peterson with the Wall Street Journal. We are joined today by my colleagues, columnists Alicia Finley and Kim Strassel. Welcome to you both. Before we get to Nikki Haley's recent speech, let's close the loop on the Supreme Court's case on Mifepristone, sometimes called the abortion pill. And Alicia, as I understand the lay of the land here, there's a federal district court judge, Matthew Kacsmaryk, who suspended the FDA's approval of the drug in 2000, as well as some later changes that the FDA made to the dispensing rules. That was appealed. The Fifth Circuit put the first piece of that decision on hold, but not the second. And now the Supreme Court has stepped in to put Judge Kacsmaryk's ruling entirely on hold. Alicia, do I have that essentially right? And what's your view of this ruling by the court?
Yeah, I think you explained it correctly. The Supreme Court did not explain its ruling. It issued its decision on the emergency or shadow docket. Justice Alito, separately in a dissent, he disagreed with the stay, largely on procedural issues. He didn't express any opinion on the merits of the case. My view on the reason why the court did what it did was national injunction is an extraordinary remedy. Lower courts have often used willy-nilly to block policies before actually a full hearing and briefing on the merits. The Fifth Circuit actually didn't even address a lot of the questions in the case. And it goes up for an expedited review for a full hearing next month, actually in a few weeks, and where you'll actually see where more of the issues, including whether the plaintiffs actually have legal standing, which I'm actually quite skeptical of in this particular case, because it doesn't seem to me that the plaintiffs in this case are pro-life physicians who claim that they are being harmed because they have to treat women who come into the emergency rooms after taking these pills and have adverse side effects. And then the reason why I'm questioning whether they can actually have legal standing to sue in this case is because, well, you can make the same argument. A lot of physicians have to treat patients who come in because of side effects from some drug that the FDA approves. You know, all drugs have side effects, right? And so you can't trace that back to the FDA's actions to approve the drug, or in this case, even the FDA's relaxation of the dispensing requirements. So that's why I think eventually, if and when, and probably will go back up to the Supreme Court, I think it could just get dismissed.
To underline the point that Alicia made, the Supreme Court did not give a reasoning for its decision here. It just says the applications for the stays are granted. So I agree that what's more interesting is the dissent from Justice Alito. And part of what is motivating that dissent is the fast track that this case is already on at the Fifth Circuit. Apparently that argument is going to be had within the next 25 days or so. So he thinks that the relief that the parties want might be soon on the way anyway. But Kim, he also has some shots at previous criticisms of the so-called shadow docket. And in some public remarks, Justice Alito even took issue with that term. At one point, he said that this should be called the emergency docket because there's a court somewhere that issues an order or an injunction, and the parties appeal upward and they say, if there's not a stay issued, we are going to be irreparably harmed. And so we would like a higher court to issue a stay. And eventually that climbs to the Supreme Court. And in other cases, the justices on the liberal side of the bench have taken issue with that. And he quotes some dissents from Justice Elena Kagan saying that the court barely bothers to explain its conclusion, emblematic of too much of this court's shadow docket decision-making, which becomes every day more unreasoned. There's another quote he pulls out from Justice Sonia Sotomayor. And Kim, it's an interesting kind of shot across the bow here because Justice Alito says that he did not agree with those criticisms in those cases, but he's making the point that the critique of the so-called shadow docket seems to depend on whose ox is getting gored here.
Precisely. And I think it's worth noting that we need to get some clarity on this question of what we should call it. I agree with him that it should be called an emergency docket. And unfortunately, it's one that's being called upon more frequently. Why is that? Well, partly because you have Democratic administrations and bureaucrats that increasingly are putting out orders or rules that are untethered from the law, or they come up with some really dubious legal thinking for how they can justify their actions with very far-reaching consequences. We've seen this numerous times with the Biden administration already, whether it's the extension of its eviction moratorium, whether it was some of its vaccine mandates. And in those cases, the case went quite quickly through the courts, and the Supreme Court was asked to take an action to either stop or allow stuff to go forward. We're also seeing it because increasingly we have judges that are themselves putting nationwide injunctions on practices. This was something that was virtually unheard of before the 1960s. And I have some interesting numbers here. During the entirety of the Bush administration, there were only 12 nationwide injunctions put out. During Obama's year, there was 19. And then things got really rolling in the 4 years that Trump was there. There were 55 nationwide injunctions because of justices that just didn't like things that the Trump administration was doing. So increasingly, the Supreme Court gets called in to adjudicate these. And yes, in the past, you've had the other liberal justices and progressives lambast the court saying, how dare you get involved here on an emergency basis? And they called it the shadow docket. And I think it was good of Justice Alito to note that, all right, well, here we're doing it. In this case, you agree. So is the emergency docket something that is necessary or not? Now, Alito would argue that he looks at each of these cases on the merits and makes the decisions on the merits. And I think that that's a fair point. But at some point, progressives need to decide whether or not they approve of the court occasionally stepping in or not, because it's going to continue happening, these requests.
But if this is going back down to the Fifth Circuit, Alicia, what does that mean for the timing when it eventually comes back up, as it probably will, back to the Supreme Court? Is this something that is probably going to be happening in the heat of the 2024 election? Because, Alicia, you've said that you're very skeptical of this lawsuit, and particularly the standing that the plaintiffs had. But I could also see it turning into sort of a media circus. I mean, recall the case about whether the entire Affordable Care Act was going to be struck down because Republicans had zeroed out the penalty for the individual mandate, which was the thread that unraveled the whole thing. And there were quotes floating around. Here's one from Chuck Schumer. "The American people should make no mistake. A vote by any senator for Judge Amy Coney Barrett is a vote to strike down the Affordable Care Act and eliminate protections for millions of Americans with pre-existing conditions." And obviously, that is not what ended up happening. The Supreme Court ruled 7-2 that this case did not throw out the entirety of Obamacare. And there could be a similar dynamic here, Alicia, even if the underlying lawsuit here is as weak as you seem to think it is.
Right. If you recall with Obamacare, they threw it out because of the standing issue, right? And Gorsuch and Alito dissented on that. And they made actually some interesting points about how the court's jurisprudence on standing has been very inconsistent. Liberals are likely to grant standing in particular cases where they are inclined to rule in certain ways. So a lot of the court, to Kim's point, actually, a lot of cases end up coming up to the Supreme Court on the shadow docket, in part just because sometimes lower court judges just aren't as stringent on when they review these cases for legal standing. But putting all that aside in terms of the timing, now I would expect if the Fifth Circuit hears the case next month that you'd get a ruling probably sometime summer. It'll be appealed by one or both parties up to the Supreme Court. They'll probably grant cert, and they may agree to hear it on an expedited basis, as the Fifth Circuit is doing. And so you'd probably have the court hear it in the next term, whether that be the fall or the spring, with a decision coming down by the summer of 2024. So that would still be before the election, the 2024 election, but it could factor into the GOP primaries. It could factor into, who knows if Biden will actually get a primary challenge, but it'll allow Democrats to continue to keep this issue in the news, which plays to their advantage, as we've been seeing in the Wisconsin Supreme Court race. They want to keep the focus on abortion and make it seem like Republicans are trying to severely restrict abortion rights. And I think in some ways, the plaintiffs are really playing into their hands here.